broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. When I ask if you understand your rights, I'm referring to the rights I just explained and how I'm conducting the hearing today. Those who receive a signature bond today will be reset for the notice. Those who receive surety or cash bonds will be reset to our state all-purpose calendar, whereby aspects of the case can be revisited, including contact bond and other matters as necessary at that calendar. Ms. Tucker needs to interview a couple clients. I'm hoping that those clients are at courtroom two, and she can give courtroom two a call, and we can take parties that belong to Mr. McLean.
They're at ACDC, the females.
Oh, okay. It never quite works out. Will ACDC be logging on shortly?
Yes, ma'am. She just finished up in the NC1 calendar.
Okay, thank you. All right, who do we have first at courtroom two?
You can start position 8, position 9, Miss Lester.
Okay. Ms. Lester, good afternoon. Your case is 25 CR 003599E. You're charged with simple battery, family violence. You understand your rights today?
Yes, ma'am.
All right, this is her first arrest. So, Mrs. Sirocco, we will go to you.
Thank you, Judge. This incident took place, this was June 26, 2025 at 173 Woodward Avenue in Atlanta. It's an apartment complex. Law enforcement responded to a domestic dispute call at the residence. Upon arrival, the officer made contact with the victim, Miss Jordan Haynes, Haynes, Giordan, who explained that the defendant, with whom they're in a current relationship and they reside together, had forcefully snatched her cell phone from her hands while she was watching videos. The defendant asked the victim to turn down the volume. Victim said no. And the defendant snatched the phone, returned it, and then snatched it from her hands again after the victim wouldn't turn the volume down. The defendant then struck her multiple times with an open hand while the phone was being taken. State's recommendation is a signature bond through pretrial services, her to complete FIB, have no further contact with Jordan Haynes, Giordan, Haynes again. Stay away from the apartment complex located at 173 Woodward Avenue, Southeast Atlanta, and no drugs, weapons, or alcohol while out on bond. We have not spoken with Ms. Haynes yet. We will continue those efforts, but we would nonetheless ask the court sound for her.
All right, is Ms. Hayes present and wishes to make a statement? Okay, Mr. McLean, do you object to a signature bond through pretrial services at level 1 with a 1-day anger awareness course, no contact, and a stay away?
Excuse me, Judge Williams?
Oh, hold one moment. Mr. McLean, this is your client. You're muted. Mr. McLean? Mr. McLean, can you hear me? Is this your client? You're muted.
Here we go.
All right, any objection to that, Mr. McLean?
Your Honor, I was just speaking with Ms. Figueroa on the other desk phone. Which case are we on?
Ms. Lester, the state has requested a signature bond through pretrial at level 1 with a 1-day, and they requested FVIP. I'm saying that there would be a signature bond with the 1-day anger awareness, a stay away, and no further contact.
That's fine. I anticipated that would be a signature bond. We have Ms. Lester's paperwork here. Thank you.
All right, defendant is going to receive a $3,000 signature bond at level 1 through pretrial services. I'm allowing her to sign her own bond. She's going to take a 1-day anger awareness course. She's to have no contact with the alleged victim and stay away from that location. She's to have no alcohol, no drugs, no weapons, and she will be reset for the notice. Ma'am, this Miss McNeil, this is just a bond hearing. The only party I'm going to hear from today is the alleged victim in this case, which you are not. There will be other proceedings regarding this where your testimony may perhaps be relevant. I've allowed the defendant to sign her own bond, all right? All right, we're gonna move to the next case. If you have questions, you can perhaps give her attorney a call. Best of luck to all parties concerned. Who do we have next?
Position 8, Ms. Figueroa.
All right. Ms. Figueroa, good afternoon. Your case is 25 CR 0035, 36098. In this case, you are charged with battery, family violence, and simple battery, family violence. Do you understand your rights today?
Yes.
All right, Mr. Howard.
Fifth arrest, 2024 Frey, dismissed. 2016 assault and battery, dismissed. That's it.
Okay, Mr. Nixon, please proceed.
Yes, good afternoon, Your Honor. This occurred on June 26, 2025. Officers responded to Georgia State University Monitoring Center, that's 141 Piedmont Avenue, regarding a physical altercation between two females, later identified as the defendant and the victim, Marnia Terrell. Video footage provided by the GSU showed the defendant grabbing Terrell by the hair and dragging her down the sidewalk, resulting in both of them falling into ongoing traffic on Piedmont Avenue. In the video, it showed the defendant snatching the victim's phone and throwing it, and then walking away. The defendant admitted to being in a relationship with the victim and currently living together as a couple. Seeing the criminal history and the facts of this case, Your Honor, the state's going to recommend a SOB through pretrial, no further contact with Marnia Terrell, no alcohol, drugs, or weapons while out on bond, as well as FBIP, and the state would ask the court to sign for the victim when appropriate.
All right, Ms. Terrell, I see you present on the screen. If you wish to make a statement, please unmute and turn on your camera, raise your right hand, and I'm going to give you some instructions before you speak if you wish to do so. Again, I'm sounding for Ms. Terrell.
Yes, I'm just trying to figure out how to cut everything out.
All right, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury? You're muted. I can't hear you.
Yes.
All right, let me give you some instructions. Whether or not you disagree or want to add to the facts that Mr. Nixon just presented, that's not what I'm concerned with today. This is a bond hearing and the defendant is entitled to a bond today. What I'm most concerned about is whether you wish to have contact with the defendant in this case and whether you have any concerns for your safety. That's of primary importance to me. In light of those instructions, Ms. Terrell, what would you like to tell me at this time?
I do wish to have further contact with her as we do live together and we have, of course, business to attend to. I don't feel like I'm in any future harm.
Okay. I do appreciate you coming to court and making that statement, okay? All right, Mr. McLean?
No objection, Your Honor. The client and I were talking on the phone just now about any further services that would be helpful in her life. She is a Georgian now. She's moved here from North Carolina, and we would ask the court to follow what the state recommended, except that FBIP, I think, would be premature if at all appropriate. Something else, something lesser would be fine.
All right. Defendant's gonna receive a $4,000 SOB at level 2 through pretrial. It's broken down 3,000 on count 1, 1,000 on count 2. She's gonna take a 2-day anger awareness course, and she's to have no further violent contact with the alleged victim, last name Terrell. In this case, she's to have no alcohol, no drugs, no weapons, and will be reset to the reset for the notice as she is receiving a state and bond at level 2. Is there anything additional from state or defense?
Nothing.
All right. Best of luck to you, Ms. Figueroa. That concludes your case.
Next is position 11, Mr. Sappho.
All right, Mr. Sappho, good afternoon. Your case is 25 CR 003601E. You're charged with theft of service. Do you understand your rights this afternoon? Is that a yes? All right, thank you.
You got
Ms.
eight total. 2024 interference with government property conviction. On probation out of car for theft by taking. On probation in the cab for burglary, 2nd degree. 2020 assault trespass conviction.
Okay, thank you, Mrs. Sirocco.
Thank you, Judge. I also have that he was convicted in Washington State of burglary and assault in 2021, and that there was an additional arrest for robbery and aggravated assault from 2015 that was dismissed. This incident took place June 26, 2025 at 66 5th Street Northwest in Atlanta. It's the Waffle House. Law enforcement was dispatched there in reference to a theft of services incident. Upon arrival, the officer made contact with the manager, Ms. Shannon Newell, who explained that the defendant had ordered and consumed food from them but didn't pay for it. The manager explained the defendant was located inside the men's restroom. The officer made contact with the defendant once he exited, and at which point the defendant admitted that he didn't have the money to pay for the food he'd eaten. The manager wanted the defendant prosecuted. The state's recommendation, given the history here of theft and theft-related offenses, is a $1,000 surety for him to complete anti-theft course, stay away from the Waffle House located at 66 5th Street Northwest Atlanta, and no drugs, weapons, or alcohol while out on bond.
What was the amount for the food he allegedly consumed, Mr. Sirocco?
Somewhere in the, hold on. It was certainly no more than $30.
Yeah,
I don't have the number.
All right, Mr. McLean?
I think he told me it was $16 and some cents. If that's accurate, I would ask for either a signature bond or twice the amount of the loss, like $35 cash bond.
And that sounds correct.
I would prefer a
That's
signature
correct.
if possible.
All
He
right,
is,
go ahead,
he's
Mr. McLean.
he's taken nursing courses to get a nursing degree. His jobs have been in retail. He lives in Covington. Thank you.
All right, defendant's gonna receive a $35 cash bond. He's to stay away from that Waffle House, have no alcohol, drugs, no weapons. Because he's receiving a cash bond, his case will be reset to all purpose on the 10th. Best of luck to you, sir. That concludes your case. What do we have next?
Next is position 12, Mr. Sapp.
All right, good afternoon, Mr. Sapp. Your case is 25 CR 003603H. In this case, you're charged with simple battery, family violence, simple battery, simple assault, family violence, criminal trespass, and having a fraudulent license. Do you understand your rights?
Yes.
All right, Mr. Howard,
First,
I didn't have that as first on my list. Okay,
you said
uh,
Sap?
yeah, okay, I must have missed that one. All right, thank you. Mrs. Sirocco, please proceed.
Sure thing, Judge. And if it makes you feel any better, I have the same that pretrial does here.
Okay.
This incident took place June 25th, 2025 at 2155 McFarland Lane in Alpharetta. Law enforcement responded to a physical domestic at the residence. Upon arrival, the officer made contact with one of the victims here, Mr. James Sapp II, who explained that the defendant, his son, had shoved him into the kitchen counter sink during an altercation. That all started out when the defendant approached his brother, Justin, another victim here, while he was doing his homework and insulted him about schoolwork. The defendant threw a beer can at Justin and approached him. The officer observed spilled beer on the staircase where the family members stated that the beer had struck. When the father intervened and got between the brothers, the defendant and the father began arguing and moved to the kitchen, where the defendant shoved him into the kitchen, that kitchen counter sink there. The defendant struck his brother Justin in the face as well, and there was a physical altercation that ensued involving what sounds like the whole family here, because the defendant broke free. Everyone was trying to restrain him. He broke free and left through the garage, where he rushed toward his mother, the third victim here, Miss Allison Sapp, who struck him in the forehead with a flagpole in self-defense. The officer observed a wound on the defendant's head from that. The defendant then walked toward the father's vehicle and threw a phone at it hard enough to dent it, hence the criminal trespass here. And the officer observed said dent, along with a footprint as well from on the door window where he kicked it. The defendant was found at Milton City Hall, where he was taken into custody, and on his person was a fake Georgia driver's license. The defendant refused to speak with officers about the incident and was transported. We have spoken with the victims and they expressed Miss Sapp in particular expressed her desire for her son to participate in anger management classes, morning anger management classes, and drug and alcohol treatment programs. Both victims acknowledge that their son has anger issues and emphasize the importance of him receiving help in that area. They shared as well that the defendant currently has an apartment in Florida and will likely reside there upon his release. Mr. Sapp stated they wanted to drop the charges, and both victims expressed a desire to maintain contact with the defendant here. However, we don't think that's a great idea at this time until he gets his anger and drug issues in check. So we will be asking for no further contact and to stay away. I believe they are on the line. We would ask the court sound for them while they reported feeling okay. They expressed and still do remain concerned about the defendant's anger issues. State's recommendation is a signature bond through pretrial services for him to complete FFIB, ADET with random screens. We'd be fine with remote reporting if he is.
How are you gonna do the random screens remotely though? He's in Florida. I don't think that's an option. But go ahead, I'm listening.
Okay. No further contact. Sorry, Judge.
No, I'm just thinking out if the state's requesting a random screen but saying he can report remotely, I don't see how that's gonna happen. So okay, but continue, Mr. Sirocco.
All right, and we would be asking for no further contacts with the three victims here: James Sapp II, Allison Sapp, and Justin Sapp. If we're going to revisit contact, it should be at a later date. This is a fresh incident, and there are clearly a lot of issues involved here. We're asking for a stay away as well, for the same reason, from 2155 McFarland Lane in Alpharetta. No drugs, weapons, or alcohol while out on bond.
Okay. Okay, give me 1 second. Mr. Howard, if he's out, I'm just before I hear from anybody. If I allow remote, he would be able to report via Zoom. I know you can't do the random screens, but if he is a resident of Florida, he can report remotely.
So he doesn't live here.
I'm assuming that the information I just got is he's probably going to Florida. We'll confirm that in a moment. But if I do
What level is
that,
this? 1?
I haven't done anything yet, but I'm thinking out loud.
Level 1 is phone report. So
I was thinking beyond that. Okay. If I did level 2 or 3, he could report via Zoom.
normally they have to come in.
Okay. I'm gonna think about it. All right. Mr. Sapp, I'll hear from you first. If you'd like to make a statement, please unmute your camera and raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I do.
All right, thank you. You can put your hand down. You may have heard me give instructions before. Again, this is a bond hearing. There'll be other hearings whereby they'll have the opportunity to further develop the facts about what happened. I'm most concerned with your desires for contact and any concerns you have for your safety. In light of those instructions, please give me your perspective. All right, please proceed.
I plead with you very much that we can have contact with our son, and I do not fear for my safety at all with him. Please allow us to have contact with him. I understand it's fresh, but this has not happened before in the past, any physical contact of whatsoever. So I plead very much that you let us have contact with him. I do not fear for my safety at all.
Okay.
Thank you.
Thank you. Ms. Sapp, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
I do.
All right, please proceed with the same instructions in mind.
We love our son. I know we made a mistake, but he's part of our family. I really do beg you to not make him have no contact with us.
All right, I appreciate you coming to court and making that statement. All right, Mr. Allen, I'm assuming you represent this party. I apologize if I had known and seen you earlier, we would try to take your case first.
No
Please
problem, Your Honor.
proceed.
Your Honor, we have no objection to the signature bond. This is his first offense. He's a graduate of Milton High School. He's 19 years old. He was in welding school in Florida and was home working a job and does plan to return back to Florida. So we would ask that he can go back to Florida. And as his parents have just said, they do not fear for their safety. They want to have contact with their son. This is an incident that their family wants to work through together. He's 19 years old. So I would ask that he can have contact with his family members, including his brother, who's not on the call today, and that he can return to that address. And we would oppose the Family Violence Intervention Program. I don't know if this case and these circumstances are the right fit for that program, but we have no other objections otherwise.
Okay. I'm not opposed to the SOP pretrial. I am just trying to think about I do kind of feel that some random screening might be appropriate in this case, Mr. Allen and Mrs. Sirocco, but is he going back to Florida to your knowledge, Mr. Allen?
To my knowledge, yes.
Okay. All right, let me think about this for a second. Let me look one thing up. I'm reading the warrant at the same time. If I do an ADET, he could do that. And any recommended treatment, he could do that in Florida, correct, Mr. Howard or Mrs. Sirocco?
I believe so, Judge.
I have no idea.
I think so. I think he could do, Mr. Allen, I'm considering doing an evaluation. He would have to do that privately somewhere in Florida. Is that something that you believe your client can handle if I allow him to return to the state of Florida? Because if I do random screens, he would have to be here in Georgia and that would, he couldn't, we wouldn't be able to go the route that I'm thinking we're going.
Yes, Your Honor.
Okay, so what we're gonna do is defendant is gonna receive a $5,000 signature bond through pretrial at level 1. He can do the phone recording. He is gonna undergo an ADET. He's gonna be reset for the notice. He's to have no further violent contact with any of the alleged victims in this case. All right, is there anything additional from the state or the defense?
What's the breakdown, $1,000 on each charge?
A thousand each charge, yes, ma'am. And it's at level 1 through pretrial services.
Judge, did you say no further contact or no further violent
I
contact?
said no further violent contact with any of the parties in light of the statements made today. All right, I believe that concludes this case. Is there anything additional?
Nothing further from the defense, Your Honor.
Nothing
All right.
from the Judge.
And I'm sorry, before we do this, one other thing. How old is this defendant?
He's 19, Judge.
He's 19. I'm gonna require 10 hours of community service as well. All right?
Understood.
All right. Best of luck to all parties concerned. The matter is now concluded. Who do we have next?
Next
Thank
is,
you, Judge. That concludes my business, if I can be excused.
Yes, you may. Take care. Have a good afternoon.
Thank you. You do the
next
same.
is position 14, Mr. Washington.
All right, good afternoon, Mr. Washington. Your case is 25 CR 003606A. You're charged with battery family violence, 2 counts and 1 count of simple battery family violence. You understand your rights today?
Yes.
All right, thank you, Mr. Howard.
Fourth arrest, 2011 fugitive from justice, 06 trespass, NOD.
Okay, thank you, Mr. Sirocco.
Thank you, Judge. And just to confirm, this is Mr. Washington?
Correct, position 14.
Okay, thank you. This incident took place March 21st, 2025 at 1064 Herndon Street Northwest in Atlanta. A 911 call came in by a woman who was reporting that she'd been assaulted by her ex-boyfriend at the residence. Law enforcement responded, made contact with the victim, Miss Alice Sanders, who explained that the defendant, who used to live with her as her roommate, had punched her several times in the face when she came to collect the rest of her property. She stated that once she arrived, she discovered some property was missing. And when she asked him about the missing property, he became upset and started attacking her. The officer observed that the victim sustained a swollen shut right eye, swollen shut, and that her mouth was bleeding from the incident. An ID of the defendant was made, via his ID photo and victim confirmation here. And a warrant was issued for his arrest. The state's recommendation for this case is a signature bond through pretrial services for him to complete the Family Violence Intervention Program, have no further contact with Alice Sanders, stay away from 1064 Herndon Street Northwest in Atlanta, no drugs, weapons, or alcohol while out on bond. And we have not spoken with Ms. Sanders as of yet. We'll continue those efforts, but we would ask the court sound for her at this time.
All right, is Ms. Sanders present, wishes to make a statement? Hearing none, Mr. McLean?
Generally speaking, no objection. We don't object to the signature bond. We feel that FVIP would be premature, but otherwise, he's got some college and he's worked in graphic design for 8 years. That sounds good.
Okay. Look at some. Oh no, hold on. Read one thing. All right. Defendant is going to receive a $3,000 signature bond through pretrial services at level 1. He's going to take a 1-day anger awareness course. The breakdown is 1,000 each count. He is to have no contact with Ms. Sanders, stay away from that location, have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing, Judge.
Nothing.
All right. Best of luck to you, Mr. Washington. That concludes your case.
Attorney Tucker, are you back on?
I'm sorry?
I was asking if it was Ms. Tucker was back from the.
Oh, Ms. Tucker, I don't think she's back.
Okay. That was all for Mr. McLean's clients. The bond was paid for positions 10 and 13, so we won't be seeing them.
Okay.
And positions 5 and 6 waived. That was also Mr.
Oh,
Tucker.
they wait. Oh, but that's Ms. Tucker.
Yes.
You said bond was paid for position 10?
10 and 13, yes.
Okay. All right. Judge, I'm going to be filing a motion to revoke an existing bond with respect to that case. I will send it to the court.
Which case is it?
Oh, what grounds?
Isaiah Reeves, this was he's in violation returning to the MARTA there of an $8,000 good bond issued by Judge Mincy back in April.
Okay.
Would I send that to Your Honor, or would I send it to the?
That's a good question. He's already bonded out.
Mm-hmm.
I have to think about that. I really don't know. Typically, that's something we hear at SAP sometimes. Ms. Lewis, where could I put that motion? Because the defense has to have time to respond, I'm assuming.
They're gonna file a motion on
position 10 to revoke bond.
revoke bond on the previous charge.
I guess so.
Yeah, the existing case is.
What was the violation date of that previous case?
We used to have a revocation calendar. I guess we haven't done that in a long time.
The case number for the case that he's in violation of is 25 CR 002010Y.
And he posted a surety bond on that case.
Yes, that's Judge Edie.
Yeah, he posted his bond on that case. So the hearing will have to go before Judge Edie.
I think so, right? I don't think it can go to
you have to file that in front of Judge Edie for that case to revoke the bond in that case.
During the pandemic, we had revocation hearings, but I think those have been returned to the division.
Understood. Would anyone happen to know the litigation manager's name for Judge Edie?
Yeah, her name is I'll send it to you in the chat. Her name is Jewel Powell.
Okay.
I'll send it to you in the chat. But yes, that case will have to be heard before Judge Edie.
Okay, thank you, Ms. Lewis.
Go for that point.
I haven't heard a bond revocation argument in several months, Mrs. Sirocco.
Yeah, I wasn't expecting it today either. Is it just Ms. Tucker's cases that are outstanding?
Correct.
Okay.
So, Judge, you know the last case we just did, Washington. Um, can you recall what was the address he was supposed to stay away from?
1064 Herndon Street.
Is that where he lived at?
Thought that was the incident location. Let's confirm,
Yeah,
Mrs.
'cause
Sirocco.
I'm reading the warrant. It says that he lived there.
Oh, he used to live there. It's my understanding that she now lives there. If you read a little bit below, they used to live together and he was coming over.
I thought she was,
Right.
I thought
Let
he,
me confirm. Hold on.
no, okay, go
Because
ahead.
I feel like I'm kind of contradicting myself.
Yeah, because I was reading the total opposite what you just said.
Yeah.
Because that's the address he has on his, I heard she was vacating the Pacific
Mhm.
facility, not him.
Let's see. Okay. Oh, that's correct. So we would not be asking for a stay away there. I completely had that flipped.
Thank you for the
Miss Tucker, are you back? Miss Tucker?
Well, she must be on the phone with them because she's not in the breakout room.
Okay, well, we'll just hold.
I'm sorry, Your Honor. Did you call my name?
I did. I was trying to see if you had made progress, or do you know about how much longer you'll need to conduct your interviews?
I'm finishing up with the last one right now.
Okay, all right, we'll hold for your report. Thank you.
Sorry about that.
No problem. Thank you. I just want to check in.
I'm prepared to move forward, Your Honor.
She'll be right back with y'all. Give her a minute. The judge be back in 2 minutes. Please be patient.
All right, thank you for your patience. I'm ready to proceed. Who do we have now?
Position 1, Ms. Argo.
Okay, Ms. Argo, your case is 25 CR 003602G. In this case, you are charged with criminal trespass. Do you understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard?
60. She got 2 counts of open trespass, open shoplifting out of DeKalb County, open case out of Mississippi for profanity, drunkenness in public place, false information, 2025 fade to appear, 24 shoplifting no load, another 24 shoplifting no load, 2 trespass from 2023, 2021 trespass obstruction no load, 2015 obstruction no load.
That's good. Thank you. Mr. Nixon?
Yes, Your Honor, this occurred on June 26, 2025. Officer was dispatched to 639 Morosgo Drive Northeast. That's a Chevron located at that location. Upon arrival, officer met with the caller, Mr. Sultan Ali, reported that the defendant, whom he recognized from previous incidents, where she was criminally trespassed from the location for damaging one of the gas pumps by breaking the hose off and threatening to burn down the business. She returned there to the location. He also advised that she was asked several times to leave the property that day, but she still entered the store. He stated that the defendant walked past security and entered the store. Once inside, she went to the refrigerator, took 2 bottles of the 200 margaritas and drank them, and told him to told them to call the police. He didn't want to press charges, but he wanted criminal trespass because the defendant had cost him over $5,000 in damages in the past couple of months. Per the criminal history, I've noted several FTAs, probation violations, and a numerous amount of criminal trespasses. The state's going to recommend $500 surety for the criminal trespass, stay away from the location, no alcohol, drugs, or weapons while out on bond, as well as alcohol, drug, and evaluation treatment.
Okay. Ms. Tucker?
Miss Argo is 47 years of age. She's an Atlanta native. She's maintained the same residence since 2009. She has a 10th grade education, and she's currently employed as a housekeeper. And she has 2 children. We are requesting a signature bond on her behalf. She states that she was unaware of a criminal trespass because she shops at that Chevron every day. After the previous incident, she was hospitalized. She was having a mental breakdown. And since she was released from the hospital, she's been back to that location several times, and she didn't have any issues until her arrest date yesterday. Due to her medical issues, as well as her concern with getting back to work, losing her job as a housekeeper, we're requesting this signature bond on her behalf.
All right, defendant's gonna receive $1,000 surety bond. She is to have, she's to not return to that location. She needs to stay away, have no alcohol, no drugs, no weapons, and she'll be reset to all purpose on June the 10th. Is there anything additional?
It's July the 10th, Judge.
I'm sorry, July the 10th. My apologies. Years going too fast. All right, best of luck to you, Ms. Argo. That concludes your case. Who do we have next?
Next is position 2, Mr. Brooks.
Mr. Brooks, good afternoon. Your case is 25 CR 003604A. You are charged with criminal trespass. Do you understand your rights? All right, Mr. Howard.
7 total. You gotta open criminal damage to property, 2nd degree. It's 25 PI 004207. On probation for trespass, damage to property, 25 CR 000234J. 2023 trespass, 2023 battery conviction.
All right, thank you. Mr. Nixon?
Yes, Your Honor, this occurred on June 26, 2025. The defendant walked into the property located at 4915 State Route 14, and it's in Union City, which is owned by Shashikira Shetty. I'm gonna spell that first name for you. SHASHIREKA. Last name SHETTY. The defendant was issued a criminal trespass warning on June 25th, 2025 by Officer Atkins. Per the criminal history notated by pretrial and the facts of this case, the state's going to recommend a $500 surety for the criminal trespass, no further contact with the victim here, and to stay away from the property at 4915 State Route 14, Union City. No alcohol, drugs, or weapons while out on bond. The state would ask the court sound for Ms. Shetty when appropriate.
I'm signing for that party now, even though it's criminal trespass. I will hear from them if they're present. All right, Ms. Tucker.
Mr. Brooks is a 30-year-old Atlanta native. He's currently experiencing homelessness. He's completed high school and he is also currently unemployed. Um, he has no objections to stay away from the incident location. And we are requesting a signature bond on his behalf or the lowest possible bond that the court will allow for this matter. Due to his financial standing and his homelessness, he will not be able to make bond on a surety bond today.
Okay. All right, defendant is gonna receive $1,000 surety bond. He is to stay away from that location, have no alcohol, drugs, or weapons. I'm gonna ask that a social worker meet with Mr. Brooks, and he's gonna be reset to the July 10th state of purpose calendar. All right, who do we have next?
Next is position 3, Mr. Carpenter.
Mr. Carpenter, your case is 25 CR 003611Y. You're charged with simple battery and battery. Do you understand your rights?
Yes, Your Honor.
State, I got first arrest. I'm not sure what you have.
Same.
Okay.
All right. All right, please proceed, Mr. Nixon.
Yes, Your Honor. This occurred on June 25th, 2025. Officer was dispatched to 26 Pine Street in reference to a physical domestic dispute. The caller and the victim, Stephen Smith, dispatched that his brother-in-law, later identified as a defendant, pushed him to the ground. He also advised that he was being strangled by his sister, later identified as Kimberly Frost. Upon arrival, officers made contact with all parties inside the residence, and the officer observed Smith lying on the kitchen floor, and he advised he was hurting and needed medical attention. When asked what was hurting him, Smith stated he was having back pain due to being taken to the ground by the defendant. Officer asked Smith what led to the physical altercation between him and the defendant, and Smith replied that he was calling Frost derogatory names and that Carpenter took offense to it. It was said that the defendant then took Smith to the ground and started strangling him. Smith was in an inebriated state, so what the report says, and the officer then spoke with the defendant about the incident. He advised that Smith had been acting belligerent and was calling Frost names and stated that he took Smith to the ground for de-escalation purposes. Although he stated that Smith was not being physical with anybody and then mentioned that Smith may have been physical, then pled the fifth. Per the criminal history and the facts in this case, Your Honor, the state's going to recommend an SOB through pretrial, no further contact with Stephen Smith to promote a cooling off period, to stay away from 26 Pine Street, Roswell, and no alcohol, drugs, or weapons while out on bond. And the state would ask that the court sound for the victim when appropriate.
All right, is Mr. Smith present? Ms. Tucker, do you object to the signature bond, which I'm inclined to grant?
I have no objections to the signature bond. However, I do have an objection to the stay away. The incident location, 26 Pine Street, is Mr. Carpenter's residence. He's actually the homeowner there, and Mr. Smith was simply a guest at his residence. So we are asking that he be allowed to return home upon his release.
All right, and the allegation is not such that it's not charged as family violence, so that shouldn't be a problem. Okay, defendant is going to receive a $2,000 signature bond through pretrial services at level 1. He's going to take the 1-day anger awareness course, have no contact with Mr. Smith. I am not going to restrict him from his home, however. And additionally, he said no drugs, no alcohol, no weapons, and will be reset further notice as he received the signature bond. Is there anything additional? All right, best of luck to you, Mr. Carpenter. That concludes your case. Who do we have next?
What was that amount?
2,000, 1,000 each count.
And no further
No further contact.
All right.
And good afternoon, Judge. This is Knox Allen again. I was wondering if I could get the clerk's information to obtain a copy of Mr. Sapp's bond order.
Oh, I'm sure she's working on it. We just signed it. She's doing a lot, but Ms. Lewis will send it to you as soon as she can. Ms. Lewis, will you put your email in the chat for Mr. Allen when you can?
And thank you both so much.
All right. Who do we have next? Do we have an ACDC?
Position 4, Ms. Collins at ACDC.
All right, Ms. Collins, please come forward. Your case. Oh, is anybody there with you? Okay. They're not gonna be able to unmute you, so you're gonna have to nod for me. Your case is 25 CR 003607C. You're charged with criminal trespass. You have an absolute right to remain silent. You have a right to an attorney today, and I'm conducting this hearing by video. Do you understand your rights and how I'm conducting the hearing? All right. Mr.
Collins, third arrest, two suspended license from 2024. She's a resident of Jupiter, Florida.
Okay, you said 2 suspended license 2024. That's all you see?
Yes.
Thank you. Mr. Nixon?
Yes, Your Honor, this occurred on June 3rd, 2025. The defendant was evicted from 3030 Continental Colony Parkway. That's unit 7102, located at the Greenbrier Glen Apartments. Let's see, the eviction was carried out by the Fulton County Marshals, and that case number is 24 ED 326578, who removed the defendant and her belongings from the premises. The defendant was advised at the time not to return to the property, and despite this, the defendant returned to unit 7102 without the consent of the property and the property management. That's Elon Property Management. Forced entry was made through the front door of the unit. June 26, 2025, officer personally observed the defendant inside the vacant unit. Prior to this, the property management contacted the officer and reported the defendant had unlawfully re-entered the unit. Per the criminal history and the facts of this case, the state is going to ask for SOB through pretrial. Stay away, absolute stay away from 3030 Continental Colony, Atlanta. And that's again the Greenbrier Glen Apartments. No alcohol, drugs, or weapons while on fire.
Okay, and Mr. Brett, you represent this defendant? Who represents this defendant?
I do not.
Oh, that's yours, Ms. Tucker. Okay, my apologies. All right, Ms. Tucker, do you object to a signature bond for the jail with a stay away?
I have no objections to the signature bond. I would ask, as far as the stay away from the incident location, Ms. Collins has stated that her vehicle is still at the property. So I will request a one-time police escort for her to be allowed to pick up her vehicle if it's still on the property.
All right. Defendant is gonna receive a $3,000 signature bond through the jail. She's to stay away from that location. However, she can return one time with a member of law enforcement to retrieve her vehicle. She's to have no alcohol, drugs, weapons, and will be reset for the notice. Is there anything additional?
No, yeah.
All right. Best of luck to you, ma'am. That concludes your case. Who else do we have at ACDC?
Excuse me. I understand that. I just want to get a full understanding. Excuse me, Mr. Brent, sir. You said that I was. That's not you. That's not you. That's not your attorney. I know, but he read.
It's be full moon week. Lord.
Right, let's move along if we can. The power is flickering here in my office, and we may lose me shortly.
So this is Ms. Duncan, Your Honor, I believe.
All right, who do we have next?
Position 7, Ms. Duncan.
Shakoya Duncan, Your Honor.
Okay. Thank you, Ms. Duncan. Your case is 25 CR 003615J. You are charged in this case, Ms. Duncan, with abandonment of a child and reckless conduct. Do you understand your rights? You have a right to remain silent. You have a right to counsel, and I'm conducting this hearing by video. Do you understand all of that? Yes. All right. Thank you, Mr. Howard.
Ninth arrest, 2015, given false name conviction. 14, shoplifting, first offender.
All right. Thank you, Mr. Nixon.
Yes, Your Honor, this occurred on September 23rd, 2024. Deputy Williams was on patrol in downtown, and the deputy noticed an infant child, approximately 6 to 9 months of age, in an unattended vehicle, and this was at 206 Prior Street Southwest in Atlanta. Deputy exited the vehicle for an investigation in which she found the child was in fact alone in the vehicle and the car was running. A few moments after being on scene, two males approached the car and said that they were driving. They stated that they had brought a female, the defendant, to the cell phone repair store at the intersection. At this time, the female exited the vehicle and went in the store. She tried to run out of the store without paying for her service, and the store attendant activated the magnet over the door, locking her in the store. He advised when she seen the deputy, she ran out the back. And after going out the back door, searching for Ms. Duncan, it was determined that she had left the scene and abandoned her infant child. The two other males on the scene could not advise where she had went, and her sister was called on the scene to take custody of the child. The cameras were viewed, and the vehicle was on scene for about 2 hours. With the criminal history, I think I've noted the 2015 theft by shoplifting that was on first offender as well. I think the other recent arrest was 2018. State's going to recommend, per the facts in this case as well, the state's going to recommend $1,000 surety for the abandonment of the dependent child and $1,000 surety for reckless conduct, no alcohol, drugs, or weapons, parenting course, and to stay away from 206 Prior Street Southwest, Atlanta. Nothing further from the state.
Your Honor, I don't, I'm sorry.
Go ahead. Please proceed.
I don't have a problem with the 2,000. I just ask that it be a signature bond because she has no job or no money or ability to pay for this. This is a pro bono case for me. Just trying to help out, Your Honor. So I would ask, she voluntarily turned herself in on these charges at my bequest so she can try to get her life together and get these things behind her. So it wasn't like they picked her up on a warrant. She turned herself in, and that's why she's here. So I would ask the court with the list of things that we could have to consider: risk of flight, risk to avail themselves to the court to deal with the case. It seems like she's going to check off on all those boxes. I just ask that the court give her a signature bond, and so she can move forward and try to get this behind her. That's all.
All right, Mr. Nixon, what were the special conditions that the state requested?
There's no alcohol, drugs, or weapons, a parenting course, and to stay away from 206 Prior Street, Southwest Atlanta.
Okay. Defendant is going to receive a $2,000 signature bond at level 2. That's $1,000 on each count. She is to have no alcohol, no drugs, weapons, and she's to stay away from that location on Prior Street. I'm not going to require the parenting course yet at this juncture, but that may be appropriate. She will be reset for the notice as she received the signature bond. Is there anything additional?
No, Your Honor, but can I explain to my client? So, Ms. Dumpkin, the judge is explaining you're going to get out. It's a signature bond. So that's all you need to know right now, okay? We'll talk after you get out.
Make sure her address is updated, all right? So she don't miss any court dates.
Ms.
All right.
Okay, thank you, Your Honor.
All right, take care, Mr. Brandt. Have a good afternoon.
Bye-bye.
All right, what do we have left? The waive cases, is that all we have?
Yes, Judge, 5 and 6.
All right, so we're gonna take up the waive cases, 25 CR 003612B, in which Willie Duffy is charged with carrying a weapon, reckless conduct, and discharge of a firearm, as well as 25 CR 003616B, in which he's charged with battery and simple battery.
12. You got open case out of Fulton, 2 counts of ag assault, 2 counts of cruelty in the third, 1 count possession of a knife or firearm during the commission. It's 24 SC 002334, 2024 FTA, 2019 couple of obstruction convictions. That's it.
Okay. All right, Mr. Nixon.
Yes, Your Honor. I'll start with the reckless conduct, discharging a firearm or unlawful carry of a weapon, position 5. On January 28, 2024, officer performed a business drop-in at 1590 Joseph E. Boone Boulevard, Northwest, and while at the location, officer heard what appeared to be gunshots in the nearby area. While standing outside the location, officer saw what appeared to be black male, the defendant, walking on the sidewalk holding a silver firearm in his hand. The defendant was irate and appeared to have been in an argument. The defendant started walking swiftly in an attempt to flee the area. As the officer approached the defendant, he gave him verbal commands to stop walking and show his hands. The defendant walked behind a parked vehicle in the parking lot and kneeled down on his knees. While he was kneeling down, the officer could see him placing the actual firearm under the vehicle by the rear driver's side tire. He was subsequently detained. The officer was able to locate the firearm, and the firearm consisted of 5 rounds in the magazine. The magazine held a capacity of 15 rounds. As for position 6, that's the battery and simple battery. On February 13th, 2025, officers spoke with Ms. Tiffany Hurst, who said that she had been punched in the face by the defendant. Ms. Hurst states that the defendant became upset because he called her and she did not answer right away. Ms. Hurst stated that the defendant requested that she drop him off somewhere. When he got out of the car, she stated that he left something in the car. Ms. Hurst stated that he leaned into the car and punched her to the right side of her face. Ms. Hurst said the defendant kicked at her car and then attempted to chase her on foot as she drove away. Hurst informed the officer that she and the defendant did not reside together. They did not have any children in common, and the defendant did cause swelling to the victim. In reference to the criminal history here, notably is 2021 probation revocation. Pretrial did mention the 2024 FTA, but most notably the bond was issued on March 6, 2024, requiring the defendant to possess no firearms. And that case number is 24 PI 000657. That was ordered by Judge Drake, and that was a $12,000 total surety, and that was ag assault and ag battery. Per the facts in this case and the defendant's criminal history, as for position 5, the state's recommending a $1,500 surety for the reckless conduct, $1,500 surety for the discharge of firearm, and a $3,500 surety for the unlawful carry of a weapon. No alcohol, drugs, or weapons while on a bond, and to surrender all firearms to Fulton County Sheriff's Office. In reference to position 6, it'll be a $1,500 surety for the simple battery, another $1,500 surety for the battery, no further contact with Tiffany Hurst, to stay away from 1617 Joseph E. Boone Boulevard Northwest, and no alcohol, drugs, or weapons while out on bond. And the state would ask the court to sign for the victim when appropriate.
And I'm sorry, I do need the victim's name again.
Yes, Your Honor.
Ms. Hurst,
Tiffany
I
Hurst.
believe. Yeah.
Yeah.
Is Ms. Hurst present and wishes to make a statement? Okay, hearing none, Ms. Tucker.
Yes, Your Honor. Mr. Duffy is a 39-year-old Atlanta native. He has completed some college focusing in welding. He currently works in car detailing. We have no objections to a stay away, as well as no contact with Ms. Hurst. The reckless conduct charges from January 27th, 2024. It's not likely that he's going to reoffend or that he'll pick up another charge of that nature. It's been an extensive amount of time since he picked up that charge. We are requesting a signature bond on his behalf on all counts, or the lowest bond that the court will allow in this matter.
Okay. Thank you. Okay. All right, defendant on position 5, the case ending in 3612B. Defendant is going to receive a $2,500 surety bond. It's $1,000 on the carrying the weapon, $1,000 on the discharge, and $500 on the reckless conduct. He's again to surrender any weapons he has as appropriate. And I'm sorry, what was that incident location, Mr. Nixon?
For position 5, that was 1590 Joseph E. Boone Boulevard Northwest.
Please stay away from that location. Have no alcohol, drugs, weapons, and again, he's to surrender the subject weapon in this case. For the case ending in 3616B, defendant is going to receive a $2,500 surety bond. It's $1,500 on the battery, $1,000 on the simple battery. He's to have no contact with Ms. Hurst, and I need to clarify that location again. Mr. Nixon, what is that location?
That is 1617 Joseph E. Boone Boulevard Northwest.
Okay, I got confused. They're both on Boone. All right, and he's to stay within that location, have no alcohol, drugs, or weapons. And he will be reset to the July 10th state all purpose calendar. Is there anything additional? All right, hearing none, I believe we are complete at the SBA calendar. And
Just
it's,
with that last one, I'm sorry, for number 5, that was a $2,500 surety.
both, I gave 2,500 on both cases, so he's gotta make total on 5,000. The breakdown for position 5 is 500 for reckless and 1,000 on each of the other charges.
Okay,
On the battery case, he got 1,500 on the battery and 1,000 on that simple battery.
okay. All right, I'm ready to go over the calendar.
Thank you, Ms. Lewis.
You're welcome. All right, I do need that waiver from you, Miss Tucker. If you can send it to me, please.
I just forwarded it to you. Sorry, I sent it to Ms. Bridgewater earlier.
It's okay. It's no problem. I appreciate that. Thank you. All right, can everybody hear me? Because this thunder and lightning, I can hear the thunder rolling over here. So, okay, position number 1. Everybody know the SAP reset date is going to be July the 10th. So when I said SAP, y'all know it's the 10th. I don't have to repeat it. Position number 1 was $1,000 surety reset for SAP. Position number 2 was $1,000 surety reset for SAP. Position number 3 was a total of a $2,000 SOB through pretrial level 1. Position number 4 is a $3,000 SOB through the jail. We set further notice. Position number 5 is a $2,500 surety. We set for SAP. Position number 6, same announcement, $2,500 surety. We set for SAP. Position number 7 is a total of a $2,000 SOB through pretrial level 2. Position number 8 is a $4,000 SOB through pretrial level 2. Position number 9 is a total of a $3,000 SOB through pretrial level 1. Position number 10, it reset further notice. He was released on bond. Position number 11 is a $35 cash bond. Reset for SAP 710. Position number 12 is a total of a $5,000 SOB through pretrial level 1. And he's supposed to report VA's mail-in or
He can report via phone,
VS phone. Okay.
but he does have to do an ADET.
Yeah. Okay. Okay. Position number 13 is a total of we went over that. Total of $2,000, $2,005 split bond, $2,000 surety, which she had already made, and a $5 cash bond. And no further contact with the victim. Position number 14 is a total of a $3,000 SOB through pretrial level 1. And that should be it. Any corrections? Anything? Everybody good?
All right, hearing none, will be in recess until the SCA calendar tomorrow. Take care, everyone, and have a wonderful afternoon. Stay safe. Bye-bye.
Thank you, Judge. Have a good weekend, y'all.
All right, bye-bye.
Bye-bye.
What'd you say, Ms. Lewis? I'm
I'll get the
sorry.
documents over to you. It's gonna take some time because my Adobe Reader is acting up, so it's gonna take
Okay,
time.
well, I'm gonna sit here until I get them,
Okay, I'm
so I
doing
won't
that
forget.
now.
Okay.
All right.